Fifth District. And we are here for the nomination hearing of Mary Rudolph Black to the Probate and Family Court. I will read the letter of nomination from the governor. Dear councilors, I'm pleased to nominate Mary Rudolph Black to the position of Associate Justice of the Probate and Family Court. I submit this nomination to the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth. I'm enclosing the nominee's resume for your convenience. Sincerely, Charles D. Baker, Governor of Massachusetts. Before we start the hearing, is there anybody here that would like to testify for or against the nominee, and including the nominee? Can you stand up and we'll just take a quick vote? The first, actually, before I begin that, I'm going to introduce you. I am. I was so excited. I have someone from Gloucester. Council Mary Hurley from the western part of the state, Springfield.
Golden West.
The Golden West. Council Hurley is also a retired judge, so she has been through this process and she knows this process well as well as the courts. Council Bob Jubenville from Milton, esteemed criminal defense attorney. Council Marilyn Petito Devaney, sat on our council for over 17 years and knows
18
years now. Who's counting, he said.
And it's Devaney.
Okay.
Unless you're from Gloucester.
Unless you're from Gloucester, then you say it differently. Council Idaho and Council Theater are actually traveling today, so they will not be able to get it. Council Casey is dealing with a family emergency. She's hoping to be here soon, but we're not sure. Council Kennedy, I have no idea.
He's on his way.
He's on his way, yeah. In some parts of the state, travel is going to be difficult. So, first I'll call Attorney Mark Nestor from Gloucester, Massachusetts.
Thank you, members of the council. My name is Mark. I prefer to stand in line. Lawyers like to stand, we don't like to sit down. I've known Mary Black for about 25 years. I'm an attorney who's been practicing for about 40 years. One of the toughest jobs these days, and one of the most thankless jobs, is being a probate court judge. They're often asked to make decisions that not only impact the parties in front of them, but may impact the generations going. My experience has been, and I've done a lot of probate work, is that people, when they go to the probate court, seem to want to check the logic and the common sense of the door. It appears that always, most of the parties that appear are just deal with emotions, often freight emotions. And we expect our probate court judges to look in this crystal ball, which the court does not issue them, and make a determination of what is going to happen with the decision I make. But a key client that is really never represented in the courts, especially in divorces and especially in things like guardianships and estates, are either the senior citizen or the child. They're the ones who may have the most impact on or what happens to what the judge does, and they may have to bear it for generations, but sadly, unless the parties are wealthy and can afford guardians ad litem, they rely on the court to make sure that their best interests are protected, in addition to the mother, the father, the husband, and wife, who quite bluntly sometimes hate each other's guts so badly they don't care what happens to the child. They just want to be even with the other side. Mary's treatment and compassion for her clients, especially Mary's treatment and compassion for children, I think is a key element that most probate court judges should have. Most judges, most people that come before you, I'm sure, know the law well, although I wouldn't be here, clearly have the demeanor to deal with the court and they handle the court. But my biggest concern is this judge going to be able to take the best interest of the child and make that the priority, either the child who is the child of parents, or quite bluntly, the child who is the mother, the father of the children who now may be fighting over their estate, or may be fighting over who gets to be the guardian. My impression of Mary Rudolph Black is she will clearly be an asset to this court, and she'll be clearly an asset to protect the best interest of this key element, which is the children, which oftentimes gets overlooked and forgotten. And that, in my impression, and again, after 40 years I've only been doing this, I'm still practicing, is that This is a key element that every probate court judge or applicant for probate court judge who appears before you needs to have. Because they ultimately are probably the only ones who can place the best interest of that child or children at the forefront, which is clearly the key in any divorces where there are children. Mom and dad are adults, they can deal with themselves. What the judge does regarding relationship between mom, relationship between dad and the children may last forever, if not generations. And how she deals with that child, how she has compassion for the child, how she deals with placing the child in best interest despite the financial issues of a divorce, that's key. And quite bluntly, that's Mary Rudolph Black. Thank you.
Thank you, Mr. Yeah, oh, yes, question.
Oh, sorry.
Think you were getting away that easy?
Another lawyer got me.
Temperament is a big part of a judge, especially a probate judge. Would you agree?
Yes.
And speak to this nominee's temperament.
She has the temperament. I'm forecasting in my crystal ball how she would sit on the bench. If she sits on the bench and deals with parties and deals with conflicting cases and deals with troubling cases, if she has the same temperament that she has now, she'll be a calming influence, a calming impact, and that she will be able to listen to the parties, be they pro se or with attorneys, and treat them with respect and deferment, but also she'll still be able to manage the courtroom, so the courtroom doesn't get away from her as the judge. She doesn't suffer outbursts, she doesn't create anger, she's very professional towards the parties, she's been very professional towards me in the fights I've had with her in various cases. She's always treated me as an equal, despite the fact I'm an adversary, and I'm confident that she will bring to the bench that kind of temperament that she doesn't throw gas in the flames, but she will calm them down, which is, again, clearly critical because the parties are often wired to the hilt when they show up in front of the court. They've got their own agendas and they forget the big picture. And this is the kind of judge we need to say, take it down. You'll have an opportunity to present your case in full. You will be heard, which quite truthfully is a lot of time all the parties want to do. They just want to have their day in court and be able to present their side of the court, either through counsel and through themselves. I'm fully confident, based on my 20 plus years of knowing her, that she will do that. One other shameless plug I would like to put in is, I'm also the commander of the American Legion Post in Gloucester. I've capped Mary Black on a number of occasions. We have what they call stand-downs in the military. We bring a lot of veterans together to get them housing, to get them jobs, to get them whatever. I've always volunteered, and Mary Black's always agreed to come, and she will do legal issues for free those days. She takes time out of her busy schedule to come forward and give back to her community, and more particularly give back to veterans. The veterans are very appreciative. I'm very appreciative. And that also tells me that she has the best interest of the community at heart, and I think she will have the best interest of the parties in front of her at heart.
Thank you very much. I appreciate it. Thank you, Madam Chair.
Counsel?
First of all, I want to welcome you to the American Legion in Newton. I'm on the Women's Auxiliary and Post-War Party. I don't know if you ever come out that way. Yes.
I used to be belonging to the Women in Welfare.
Oh, okay.
I'm not going to tell you how many years ago.
My question is, how many cases did you have?
I've had a half dozen cases with Mary when I'm in opposition. I've had about 4 cases with the same side with her, different parties. She has been guardian that I've suggested at least 8 times. She's been a parenting coordinator on a number of other occasions. Quite truthfully, the reason I nominated her is I trust her, and I trust that what the decision she'll make, even if it's against me. I mean, after 40 years, you lose. One time people lose. She will take the case in front of her if it's guardian to determine what's in the best interest of the child, and she will vigorously investigate. She won't do I'm doing 5 hours, I'll whip it out real quick, and off we go. She will sit with the parties, she'll sit with the child, the children, to get to the bottom, and then she will make logical, rational findings, and then she'll make recommendations. And that's the best party can ask for. And I've crossed paths with her probate court once a week. How are you doing here this week? That's the way she's living here or whatever. And I will also watch her in action indirectly. indirectly when she deals with elderly. She has a lot of elderly cases, Rogers cases, things like that. And again, she brings the compassion. It's just not a job. I got to go in there. I got to make a determination. I got to go back and file a report. Anybody can do that. She spends the time. Where are you going today? Monday night. She's going to see a ward someplace up in Lawrence, or she's going up to Haverhill. I mean, this is not a 9-to-5 job for her. And Mary clearly treats us as something. Whatever the client needs, if I can only see the client at 8 o'clock at night, or if I can only see the client at 6 o'clock in the morning, I will see the client at 8 o'clock at night or 6 o'clock in the morning. And obviously what most lawyers discover is that we end up sacrificing often family time. She's got 2 wonderful kids to do this. But that's the...
Can you cite one example as an opposing lawyer, what side you were on and what side nominee was on?
I had a husband, she had a wife in a divorce, which potentially could have got contentious because the clients were contentious. And both sides were able, she and I were able to talk logically. We were able to address the issues. Compromise was the key issue, that we were able to work out something that the parties were happy with. I mean, they weren't totally thrilled with. When you go into a divorce, nobody's ever going to totally win, or no one's ever going to totally lose, otherwise disaster. And it took a while, but we were able to, back and forth with negotiations, back and forth with the clients. And sometimes I think it was tougher negotiating with my own client and Mary with her client than with us. But we made sure, the hallmark was we made sure the clients were satisfied that they got to say their 2 cents to each other. And we had meetings before, they were required by court to have a 4-way meeting before a conference. They're able to say what was on their mind. We were able to keep it in a low-keyed, just the facts, ma'am. And it took about a year, and we ultimately reached an accommodation. We were able to present an uncontested divorce to the court. But it takes time. She's the mold, like a lot of lawyers these days.
And how did that resolve itself?
The parties got an amicable divorce. One had 2 had, without getting into details, joint legal custody, physical custody to her client, very liberal visitation to my client, which he was very satisfied because he was working a lot. And the key thing is the parties were happy. They signed the agreement. My experience has been if the parties sign an agreement rather than a judge standing up from the bench and saying, these are my rulings, I'm going to ram it down your throat whether you like it or not, this is what I've said. It's tougher for parties if they've agreed to a divorce agreement to turn around and renege on it. You had your chance, you agreed, you're comfortable with this. And so she's of the same ilk. If we can negotiate or submit, there's sometimes you can't.
You use the word visitation. Do they still use that?
I use parenting more so.
I think that should be eliminated. I don't think any parent should be visiting your children.
My agreements these days say parenting. It says they have parenting.
I don't like that.
Well, because they're more than parenting, because most times it's joint legal custody. So with joint legal custody, both parents get involved in religion, education, long-term goals, medical, and so it is parenting. It's not just someone who shows up at the door at 5 o'clock on a Friday, picks up the kid, brings the kid back on Sunday, and that's it. Parenting is parenting. I mean, 2 parents ideally should raise the child.
So you believe in shared parenting?
Yes. If the key thing with shared parenting, as far as shared physical custody, is that both parties have to be able to communicate. If one party doesn't want to communicate, you may be able to have joint legal, but someone may have to have sole parenting. Only because at the end, the kids have to be taken care of. Any other questions?
Anybody else? Thank you, Attorney Nestor. You really do terrific work for us up in Boston.
I guess the other thing I'd say is before I went on the bench, I did a lot of probate divorce work, and for anybody who can be in it for 30 years, you either have a very good flak jacket and a very thick helmet, or you're half crazy.
I still have the helmet from my Army days. I still have the flak jacket from my Army days, and lobotomy took 20 years ago.
All right, Attorney Carol Perry from Salem, Massachusetts.
Good morning. It's an honor to be here, to be able to speak to all of you, and to be able to speak on behalf of Mary Black. I'm a practicing attorney in Salem. I've been practicing primarily in the family court for 32 years, and I've known Mary since she became an attorney. I actually had met her prior to that, but I practiced with her through that. When thinking about traits that attorneys value in their judges, words that come to mind for patience, knowledge, grace, demeanor, and presence. Mary possesses those qualities as a person and also as an attorney. Mary holds herself to high standards, and I think that if she were to become a judge, she would expect the attorneys appearing before her to rise to those standards as well, which could only benefit the litigants that they represent. Word spread fast that Mary had been nominated amongst the Essex County Bar and the Essex County Court staff. Everybody is excited at the prospect that we could have Mary as a judge. Mary cares deeply about the most vulnerable people amongst us, the children and the elderly. She works tirelessly to make sure these folks are taken care of. She's sought after as a GAL, as Rogers counsel, and as counsel for the children. I've requested Mary as a GAL on cases, and I also requested that she be appointed as an attorney for 3 children in a very difficult case. Mary's an empathetic person. She treats court personnel, litigants, fellow attorneys with courtesy, respect, and kindness. She's a staunch advocate, and she will put her all into representing her clients, whether it's litigating the case through to the end or working towards a resolution via a settlement. Most times doing both at the same time. Mary would bring to the bench her rich and varied career experiences. Her expertise as a family law attorney would make her an exceptional judge. We would be lucky if we were able to have her as our judge.
Thank you. Any questions from the councils?
No, I just thought that was very helpful. Thank you.
Thank you very much for your time. Attorney Robert Ledoux.
Good morning. My name is Bob Ledoux, and I've known Mary as an attorney since she passed the bar. I practice in Salem and have been practicing, and this is my 48th year of practice. I don't know Mary on domestic cases. My office handles no domestic cases whatsoever. We handle our cases, guardianships of the mentally ill, guardianships of people who are ill. Mary, I've had an opportunity to observe Mary representing respondents in a guardianship of the mentally ill. And it really is remarkable to see her. She's kind, she listens, and she tries to address the issues with her clients. Now, it's not an easy thing to do when you have somebody that's mentally ill and some of what their thoughts might be. But she has been absolutely amazing to watch in that capacity. Carol and Mark both spoke about Mary being a guardian ad litem. Mary has been a guardian ad litem in innumerable cases that I've brought before the Essex Probate Court. And that generally revolves around people who are ill, need emergency medical treatment, or something even more difficult. And that is withdrawal of life support. That's an extremely difficult thing for people to deal with. And quite honestly, I don't think that people realize how many of these cases are in probate. Mary's probably been involved in 25 or 30 cases with me in which there's been issues around withdrawal of life support. It's obviously difficult for an individual to make a suggestion to the court that life support be terminated. Years ago, before I represented hospitals, I did a lot of the work that I just mentioned. this role as a judge in the probate field in Mary Black.
Any questions from council?
On the issue of life support, who makes the decision?
The judge.
The judge. And who requests the decision?
Generally, Counselor, I am the one that's asking for that, representing a hospital. And what generally what's happened is that the patient's not getting better. Whatever treatment is being rendered to the patient is doing nothing more than extending the act of dying. So when we have a case that comes in from whatever hospital it might be that I'm representing, that an individual has been in ICU days, weeks, and is not getting any better, and could not live off the bed. Determination's been made by the medical staff that really shouldn't continue treating the patient. Then they would call me and I would file the paper.
Do you have to check with family members?
Oh, absolutely, absolutely.
And what do they have to sign off on?
Well, it's interesting because some of the cases are in Massachusetts. A couple of cases in particular. One called In re Dinnerstein, and another called In the Matter of the Guardianship of Earl Spring. Seem to indicate that if the family, in conjunction with the medical staff, all agree that treatment should be terminated, they can terminate treatment without going to court. What happens is, a lot of times we have no families, or we have dysfunctional families. And then we obviously then have to go for authorization.
If the patient is mentally responsive, can they weigh in on it?
Yes, they can. And that's one of the principles of medical ethics. That's the leading ethics principle in medical ethics today. Autonomy. What is the patient? It's no longer what the doctor feels is best. It's what does the patient feel is best.
So in Massachusetts, does somebody have a right to, let's say, die with dignity if he or she wishes?
Absolutely. Absolutely.
Does that have to go through a judge?
It may, again, depending on whether or not we've got a family that's in agreement. If we have a dysfunctional family again, or we have no family, then clearly it's the judge that's going to make that decision.
So if I were to decide I want to get off the equipment in the hospital, would one of my children object to that?
The child could object. As I say, go back to every hospital has at least one medical ethics committee. Now that medical ethics committee is going to give you advisory opinions. A child could object, and I've had that happen. Actually, I think I've had it happen in Mary. We had a child that was objecting to termination of life. And ultimately, the hospital medical advisory committee recommended withdrawal of life support, and the court agreed with the ethics committee.
Are there hospitals in Massachusetts who are against the patient requesting to die with dignity?
There's a case going on right now, I think probably everybody's aware of, a physician down in the Cape that has filed suit that wants to have a physician-assisted suicide, basically. That's not, I mean, it came up as a few years ago, as you remember, on the ballot as to whether or not we should have physician-assisted suicide, and it was voted down. I expect we'll see that.
So what's the status of that now? Can somebody ask to have a physician assistant?
Cannot right now, not Massachusetts. And the physician that I mentioned down the Cape is actually filed suit against the Commonwealth. Because of that.
Thank you very much.
You're welcome.
We have been joined by Council Joseph Fair from the Cape,
Morning.
Council Jen Casey from the Worcester area, and Councilor.
Good morning, I'm sorry I'm late. Snow made them call the list from yesterday before they called today's list in court, so some honorary judge that tied me up.
Uh-oh. And on that note,
And on that note.
the Honorable Teresa Fastidious.
But it wasn't a probate court judge, right?
I'm not going there probate, but I saw that when she was on me.
Good morning. My name is Councilor Duff, members of the council. My name is Teresa Fastidious. I'm an Associate Justice of the Probate and Family Court. I currently sit in Middlesex, although from 2012 and appointed up until about 2 weeks ago, I sat at the Essex County Probate and Family Court. And I am enthusiastic in my support of Mary Black's nomination to the Probate and Family Court. The 4 areas that I would like to speak about today are areas, things that Mary appeared frequently in front of me over the course of the last 5 years, in 4 very different, and in her case always successfully done areas of the law. She has appeared frequently as an attorney for a protected person in a guardianship or a conservatorship. Sometimes these are people with mental incapacities, sometimes these are people with physical incapacities, and Mary is always prepared, always knows the law, but more than that, knows her client and has a rapport with her client, which is not always what we see, which is what I really appreciate about the work that she does in that area. Less frequently, Mary has appeared on domestic relations cases, and usually those are resolved by agreement, I suspect, due to the very good counsel that she provides to her clients, as well as her ability to reasonably and effectively negotiate resolution to those cases. Mary has appeared before me, and I distinctly recall one case over the course of the last year and a half where she represented a parent in a custody case, and I was struck, quite frankly, by her knowledge of evidence and ability to try the case. Sadly, that's not something I can always say about every attorney who appears in front of me, but it stood out in my mind. And frequently, and the thing that we most rely on Mary for in the Probate and Family Court are guardian ad litem reports. And 3 stand out in my mind in the last year and a half, where she did a phenomenal job in not only guardian ad litems are appointed by the court to investigate and report back to the court on issues involving custody, parenting time, sometimes mental health issues, and it is something that we rely on tremendously. It allows us to get information, specifically hearsay. What would the child say if the child could speak in court? They do that through guardian ad litem. And they are very, very helpful to us in what we're trying to do. So there are 3 that stand out in my mind that Mary has done in the last 2 years. One involving a family with serious mental health issues, mental health issues, and at least the oldest of 3 children, mental health issues that she spent a lot of time on, spent a lot of time speaking with the family, speaking with the school that was really working with this family and providing perhaps the most stability that these children had. And she really provided great insight and great information to the court to assist in making very difficult decisions. One recently that involved a lot of changing issues in the law. It was a divorce case involving 2 women and dealt with 2 children in different circumstances, de facto parentage, legal parentage. This report gave me a tremendous amount of information, but not just the information that she gathered. It was gathered with an understanding of what the current law is and what the potential changes, and in fact changes were made to the law during the course of this case pending. That was very helpful. And a 3rd case that didn't necessarily have mental health issues, but generational dysfunction that
was also, her time and efforts were of tremendous assistance to the court. So what I would say to you about Mary is that she is fiercely intelligent, always prepared, knows the law, always ready to represent her client in the best interest. The thing that I think stands out most for me is the word respect. Mary respects her clients regardless of their standing, regardless of whatever disabilities they may have, regardless of their ability to communicate, and I think that respect shows through, and they therefore are heard and are represented well. She respects her co-counsel, she respects opposing counsel, and that gives her the ability to resolve many cases, or at least proceed in the manner that we all would like to think that we all proceed in a court system. And she has respect for the court, which is not to say the judge specifically, as it is to say the court, the system, what we all believe in and hope to work to its best potential. So that's the word that stands out for me when it comes to Mary, is respect. And she does a tremendous job, and I think that she would be a great addition to the bench. Although I will tell you that the Essex County judges say, who are we as guardians?
Thank you, Judge. Any questions? Council Beer?
Hi, thanks for coming, Judge.
Thank you.
We had a nominee last week who we went to a conversation with regarding shared physical custody. And I went through divorce and shared physical custody. How much weight do you put on the fact that, and this came up last week a lot, they said they looked at the fact of who brought the kids to the doctor, who brought the kids, dropped them off at school, picked them up at school. How much weight do you put on that fact?
What I will tell you is that every single case that we have in our court, unfortunately, is very case specific, which is why we have such discretion and why we are required to write so many findings. Sometimes what happened in the past is very useful to look at. I am cognizant of the fact that sometimes when a relationship is not working, people tend to divide. So sometimes the roles that parents take in their children's lives are different post-divorce than they were while they were living together, by virtue of the fact that, a lot of reasons that could be that we had a more traditional arrangement where one parent was home and one parent was a wage earner, and that might change by need post-divorce. So both parties might be working more, and the parent who was less involved in the day-to-day things will become more involved in the day-to-day things. Sometimes it doesn't change. So sometimes what has happened weighs into things a lot, specifically with the children, So I can't give you a blanket answer. It really is very fact specific to the family that's in front of you now. Sometimes it has a lot of weight, and sometimes it doesn't.
I like that answer because some people were of the opinion that it did, I think more than I would like it to. In my situation, I worked 2 jobs. I was a cop, I was a lawyer, so that my former wife would stay home. And if you looked at just who brought him to the doctor and who brought him to the play group, it wasn't fair to me. But then you get hit with, okay, you're a big wage earner, so now you have to pay this and pay this. And you can't have physical custody of the kids, which, by the way, I ended up with, and it worked perfectly, even though the judge told me it wasn't going to work. So I'm a strong advocate in shared physical custody. I hope you are, and I hope that's a presumption, of course, going forward. That except for factors that should be articulated and enumerated, that whether it's a man and a man, a man and a woman, or a woman and a woman, shared physical custody. Do you agree with that?
I absolutely agree that all children should have the best of both of their parents involved in their lives. I'm not much of an hour counter, you know what I mean?
Yeah.
But I absolutely, positively agree that children should have the best of both of their parents, and that works out in different ways in every family.
Yeah, well, we did 3 and 4, then 4 and 3, and happy to tell you we have 3 great grown children. I'm proud of them.
Positive thing.
Thank you. I appreciate you coming here today.
Thank you.
Yeah, thank you for your testimony. So in a case where both parties are indigent, Can you still appoint a GAL in that situation?
You can.
And who
We can
pays
have-
for it?
Commonwealth pays for it. If necessary, I mean, I think we're all cognizant of the need. We do have some other ability to get information. We can sometimes have, depending on the age of the children, we can have the probation department interview the children. And that is successful and helpful sometimes in certain situations. We can have probation do a full-scale investigation. That is difficult when our probation departments are understaffed, which they have been. Essex County is getting a little bit more back up to full staff. I think Minnesota is about at 50% right now, so it's more difficult for probation to do full-scale investigations, which is another way to get that information from indigent families. Or you can appoint a guardian ad litem and have it paid by the Commonwealth.
If two indigent parties are before the court and they both request a lawyer, is the CPCS appointing people for them?
Parties are not entitled to counsel in the probate and family court, unfortunately. It's a
Is-
civil proceeding.
Is there a lawyer of the day paid by the Commonwealth?
Not paid by the Commonwealth. There is a lawyer for the day program. It is mostly lawyers from the county who volunteer their time, but it's not paid by the Commonwealth.
Do you think they should have lawyers available?
I absolutely think lawyers should be. It's a whole different question. Beyond my scope of expertise. But it would certainly make everybody's life easier if litigants in probate court
One,
had counsel.
right by here, all over the place in probate courts, is there's just not enough people to handle the amount of litigants that come.
It is a very busy court.
1.5% of the state budget goes toward judiciary, even though it's an equal branch. We only get 5% in the difference. Do you find it's hard to get lawyers to do GAL investigations? You have enough GALs out there?
We have enough GALs out there. The issue is good GALs. That's the difference.
So if we vote this nominee in for 4 days a week, should be able to do 1 day as a guy. You happy?
It's a win-lose situation, I will tell you, because we are all very hopeful that she will soon be on the bench and that she will be our colleague. But as I said, the Essex County judges are a little bit taken aback about what are we going to do for GALs.
Yeah. Thank you very much, Judge. I appreciate it.
Casey?
Good morning, Judge. Good morning. Do you like your job?
I do.
How many years now? 5. Good. I made a note, you were impressed by the nominee's command of evidence. I wasn't aware that evidence applied in the probate court.
It does.
You know what I mean.
I do know what you're doing.
No, I do. I love evidence. It's nice to hear, it's nice to hear those comments.
Well, that's why I was so impressed
Yeah. Appreciate that. Judge, just want to ask you about grandparents' rights and visitation under Massachusetts law. It seemed like there was an evolution, and then we took a couple steps back with respect to the grandparents' rights over the years. Now, as we look around at this huge drug crisis and the opioid addiction and all these parents on these drugs, do you think it's time that the legislature maybe took another look at that statute where you have so many grandparents raising their grandchildren because of what's going on with drugs on our streets? That maybe it would be a good idea if the legislature took a look at that statute again, made it a little easier for the stable relationship with some of these kids' lives to step back in and move forward.
Well, there's two different issues involved there, because we do have a tremendous number of grandparents who are raising children right now. The crisis is prevalent, I suspect, that many courts do, the district court certainly, but in the probate and family court most definitely. So grandparent visitation is one issue, and then we have guardianship. I said it's the grandparents who are raising their grandchildren who are guardians. And then, quite frankly, I think we come to the fact that So those grandparents stand in a different place than grandparents that we would look at with regular grandparent petition. Grandparents who step in and raise their grandchildren under a guardianship that may last 2 years, it may last 6 years, it may last the entire life of the children. But if, let's say, it lasts 2 or 3 or 4 years and parents are successful in their treatment and maintain sobriety and are able to come back and parent their children, if there were, like to think not, but if there were some split between the parents and the grandparents, I think those grandparents have standing almost as a de facto parent at that point, which is different than a regular grandparent visitation case. So I can only speak to what the law is as it exists now, and there's no question but that this case made grandparent visitation more difficult to obtain.
You know, you have situations, cases, and I'm sure you can speak to this, something on it that you have a parent who has a problem, maybe they sober up for a year and a half, guardianship is pretty weak, tough legal standards to satisfy and maintain those grandparent or anybody else, and we get back in the picture and then we relapse again. I just think the courts need to be a little bit more proactive in their resolution of those cases where, you know, we have a parent who's more interested in doing drugs than loving their children or child. You know, that's what the courts are for, to protect the kids. And I'd like to see legislation more proactive, particularly we have grandparents in those types of guardianships, you know, whether it's a different legal standard and fitness standard. It's pretty hard if you have a parent who is, you know, remotely appear to have their act together, and to sometimes do place, even though that might be the child's best interest.
But fit parent that child at that time, so I think you have to take all of those factors into consideration, where the child is bonded, where the child is secure, you know, what the effect is going to be on the child, with the guardian, so it's fit, but it's fit to parent that child at that time.
I like the philosophy. And then the only other question I wanted to ask was standing orders. We've had a couple of standing orders come down the pipe recently. In your opinion, what is the force of law that a standing order has?
Well, it's certainly not precedent, but I need to follow the standing orders. I think it is incumbent on me to comply with the standing orders of the Probate and Family Court. Like standing orders, for example, the most recent one I think we had is parenting coordinators.
I mean, how do you enforce,
We have an 11-page standing order on parenting coordinators that I think recites exactly what the law was after the most recent case, which is that I cannot appoint a parenting coordinator or the objection
Yeah, I mean, when that first came out as a proposal, just, you know, a lot of practitioners looked at that and said, well, how is it gonna be enforced, how can they, it's almost, you know, at some point you get into, and even with the parents of part class requirement, you get into taxation without representation, where you have these unelected subcommittees coming up with these standing orders that literally take money out of your client's pockets without any direct input of legislature. I was just curious about, I mean, I kind of have the attitude that if my clients don't want to take the parents of our class, I'll go in and tell the judge that it's not a law. And some judges agree with that, so I'm just curious about your opinion on standing orders. They're not legislation.
No.
Thank you, Judge.
I think it's under the superintendence of the Supreme Judicial Court.
It is, and they're supposed to be procedural in nature, but when you're requiring somebody to reach in their pocket and pay money for classes and do certain things, I think you're crossing the line.
You can file an indigency affidavit.
I know.
The fee waiver for
I know they
parenting
can do
class.
that, I know they can do that, but it's just, it doesn't sit well.
I would call superintendents and ask them to come in and talk to us about that.
Well, I asked the Supreme Court nominees about whether the scrutinize those, but I agree. Yeah. Thank you.
Thank you.
Any other questions?
Have you ever had to pull the plug
I have only
order?
been asked to expand the authority of a guardian to include do not resuscitate, do not intubate orders. I've not actually had to do a removal from life support case as it's not the judge's decision, it's a substituted judgment, and our decision is to decide what would this person do if they were able to make this decision.
All right. I was new to the district court bench. A lot of those cases involve hospitals, correct? And those hospitals want to get those people out of there as quickly as possible. There's a financial end to the whole thing. I'm saying this more as a warning to you and to our nominee. I'm new to the bench. I get a call on judicial response. They want me to go to the hospital. And I go there thinking it's a DNR, not resuscitated. So we go through the whole hearing. I hear the testimony of the doctors. I'm satisfied. I'm like, okay, I'll order the DNR. Get up, leave. Oh no. We want authorization to remove life supports. Okay. It was the most traumatic and just absolutely horrendous thing that I ever had to go through as a judge. And it was a little baby. And the baby was born, a drug-dependent mother. Baby was born with the heart in reverse, the other organs outside of the body, emergency surgery, and everybody testified no possibility of sustaining life, and this, that, and the other thing. And I'm looking at, I don't know if clergy is a Catholic priest or Protestant or whatever, but behind you, that's the extra power. Greek Orthodox, okay. But in any event, I'm 16 years in Catholic schools. I believe there's somebody upstairs, and I'm saying to myself, why am I doing this? This was not what I signed up to do. And I was tears streaming down my face. I wanted to go see the babies, the incubator, heart-lung machine, and this, that, and the other thing. And it turned out that I got played by the hospital because they wanted to get this baby out of their NICU because nobody was paying for it, basically. They weren't getting the reimbursements that they should have. The mother left the hospital, left the baby, called back once to find out what color the baby's eyes were. So she'd been trying to figure out who the father was. And so on a Friday night, after a lot of soul searching and heart wrenching decision making, I ordered that the life supports be removed after taking the testimony. It was the most horrendous experience of my entire career as a judge. And I made a beeline for church the next day to talk to the priest and say, this is what I had to do. And he's like, you did the right thing. I said, just in case you're wrong and I was wrong, how about a general absolution? So, I just caution you that there's just look into the motives of what's going on in some of these cases, and it is the most difficult decision ever have to make. Thank you very much for your service. One more thing, when I was practicing in probate court, they had volunteer lawyers who would come in to mediate cases. You still do that?
The Essex County Bar has an excellent conciliation program, and they don't come into the court, but we are able to send cases where they request the conciliation program to those lawyers. And there are many, many lawyers in Essex County who do a tremendous amount of volunteer work and do a wonderful job and settle a high number of cases. The Middlesex County Bar Association has attempted and actually used the Essex County Bar program as their guide, and has attempted to set up something, and I believe is having increasing success with that program. Sort of
But they do want you to report back. You're not going to be here for a while again, unless you're. their sanity, their sense of humor, their civility, and not just getting so white with all the stuff that you see before you. We had a phrase, in district court, you see the worst people at their best, and in probate court, you see the best people at their worst. That's
Probably accurate.
So, God bless you. Thank you. Anybody else?
Anyone else? We finished with the judge?
Yeah, thank you.
Like, at this point, we're getting close to noon, where the lieutenant governor will be coming in for our regular meeting. Please all stay, because right after the lieutenant governor has concluded the meeting with us, I'm going to continue right back into this. Is there anyone else here who'd like to testify on behalf of the nominee? Could you tell us your name and your relationship to the
My
nominee?
name is Patrick McDavid. I'm the co-chair of the Probate Coalition. I had an opportunity to speak with the candidate before this hearing, and I'd like to relate some of that, but I also want to make clear about testimony we've heard today and what the nominee told me. As this body knows, we're very much for shared parenting, both legal and physical. As I've made clear many times before, I've spoken with a lot of people that have signed that agreement with the other attorney, giving up physical custody. I have never met one that knew what they were doing. So I'm very concerned when I hear that the nominee was involved in that behavior. Nonetheless, what I spoke to the nominee about was the temporary orders. And that when people come in for temporary orders, the judge usually only has 15 minutes to 30 minutes to hear the case. They really don't have the opportunity to make any judgment about who's the better parent. And unless there's something egregious going on, our position has been that is not the time or the place for anyone to lose custody of the children. It is also not the time or the place for anyone to lose time with their children, unless there's something egregious going on. On that point, the nominee agreed with us wholeheartedly, saying yes, both parents should not lose those rights at the temporary order hearing. They should be maximally involved in the child's life. 50-50 is perfectly acceptable. The other thing I spoke to her about was supervised visitation. As many other nominees have stated, supervised visitation should only be done in special cases and shouldn't be used against one parent or the other. Based on those two answers that this nominee gave to us, we do support her. We are concerned about comments from some of the witnesses, but we do support this nominee.
Thank you, Mr. McDade. Before I'm going to call for a brief recess for the lieutenant governor, I would like to submit into the record the 22 people who came to testify on your behalf at the public testimony hearing held at the Gloucester Courthouse. Chief Justice Adonez also came to that hearing because she knew she would not be able to be here today, and she wanted to let it be known in the record that she had come to hear all that testimony as well. We had more than a standing room only crowd there. I think we must have had 100 people.
150.
Yeah.
I think they want to put a statue up.
You literally couldn't fit anybody else in that room. They were standing and they were flowing into the hallway. And I will give this to you, Secretary, for those names also to be submitted into the public record is 22 additional folks who testified on your behalf. Other clergy members, doctors, teachers, attorneys who have been on both sides with you and against you, but perhaps the most powerful one was somebody who you were the attorney for her husband during the divorce and in the settlement of that family situation. And she was so impressed by you and has developed a relationship with you since that even though you were opposition, she came to testify on your behalf.
She was just glad to get rid of him.
Actually, I think you must have done a great job.
Madam Chair?
Yes.
Have we gotten word that the LG's ready?
I've gotten word that, she is ready. I just got word that she's ready. So, we'll temporarily recess this. just for a few minutes to let the Lieutenant Governor come in, and then we will resume and let you give your statement. I don't want to interrupt your statement while you're in the